Green card holders. Critical mistakes that can lead to deportation or reentry denial in 2025. Green card holders enjoy the privilege of living and working permanently in the United States. But that status comes with responsibilities. As immigration enforcement becomes more stringent in 2025, even small mistakes can have serious consequences, including denial of reentry, detention, or removal proceedings. Here's a breakdown of the key risks all permanent residents must avoid. 1. Staying abroad too long without a reentry permit. Spending more than 180 days outside the U.S. can raise red flags with Customs and Border Protection, CBP. If you remain abroad for over 1 year without a valid reentry permit, authorities may presume you've abandoned your residency. This could result in being denied reentry or sent to immigration court. 2. Not carrying proof of status. By law, green card holders must carry their alien registration card, Form I-551, at all times. Failure to present this card during a stop by federal authorities is a federal misdemeanor under Section 264(e) of the Immigration and Nationality Act and can lead to fines or legal trouble. This rule continues to be strictly enforced in 2025. 3. Letting your green card expire. Traveling internationally with an expired or near-expired green card can block you from boarding a flight or re-entering the U.S. airlines may deny boarding, and CBP may challenge your intention to maintain residency. Always renew your green card before traveling abroad. 4. Frequent or extended trips abroad. Even if each trip is under 6 months, a pattern of regular long stays outside the U.S. may suggest you don't primarily reside in America. CBP officers may question your residency and ties to the U.S., potentially leading to further scrutiny. 5. Failure to file U.S. taxes. Permanent residents are required to file U.S. tax returns as resident aliens. Not doing so may indicate abandonment of residency. Filing taxes is a key way to prove your ongoing ties to the United States. 6. Lack of evidence of U.S. ties. When returning to the U.S., you may be asked to prove your intent to live here permanently. Evidence such as a job, lease, U.S. bank account, or family members residing in the country help support your claim. Without such documentation, you may face secondary inspection. 7. Criminal convictions, even minor ones. Green card holders can be placed in removal proceedings for even old or minor criminal offenses. For example, a misdemeanor marijuana charge from 2011 led to the detention of a permanent resident despite the availability of a waiver. Always seek legal advice if you have any criminal record. 8. Detention without legal representation. If detained by CBP or ICE, green card holders may face long periods without access to an attorney or the ability to contact family. In some instances, individuals have been held without timely legal support, raising serious concerns about due process. 9. Political or advocacy activities. Under the Trump administration, a Cold War-era law has been used to target green card holders for political activities. For instance, Columbia University activist Mahmoud Khalil faced deportation over pro-Palestinian advocacy, despite having no criminal charges. Activism, even peaceful, may carry immigration risks. 10. Visa errors or misinformation. Mistakes by immigration authorities can still lead to deportation. In some cases, green card holders have been misidentified as holding other visa types or accused of abandoning residency based on incorrect data. This underscores the need to keep accurate records and documentation. Final thought. In today's climate, simply having a green card isn't enough. Permanent residents must actively maintain their status, follow all legal requirements, and stay informed about changing immigration policies. Even long-time residents with no criminal history have faced serious challenges due to administrative errors, political activities, or travel-related issues. Vigilance is essential